All right, we're now live on YouTube live stream. I want to call the hearing to order. A couple of instructions. This hearing is being conducted remotely on Zoom and live streamed on the court's YouTube channel. No recordings of this hearing are permitted. Other than by the official court reporter, if a record has been requested. Any violations of these instructions are punishable by contempt of court. Please mute your microphone and only unmute when you are speaking. Please do not speak over other participants. If there is an objection, please state objection, wait for the speaker to stop, and if they don't stop, I'll intervene. Then briefly state the basis of your objection. During this hearing, do not use the chat option unless the court grants permission. If anyone needs a private attorney-client conference or a sidebar, you may ask to be placed in a breakout room. We're invoking the rule for exclusion of witnesses in all Zoom hearings. Other than parties and counsel, any witnesses will remain in the Zoom waiting room until they are called to testify. Is that person sitting next to your client his wife, Mr. Davis?
Yes.
All right, well, she's not subject to the rule. While waiting to testify, witnesses may not view or listen to the YouTube live stream, and parties may not communicate with witnesses. Witnesses may not look at any notes or documents while testifying unless the court grants permission. All right. Mr. Davis, I think I have an understanding of what's going on. We are on the record, correct, Shana? Call your first witness.
Your Honor, do you want any type of opening statement to kind of lay out where we're going?
I think I just got that.
Okay.
Our little informal conference.
All right, that's fine. I'll go through it with the client then.
All right. Would you raise your right hand, please, sir? You solemnly swear or affirm that any testimony you may give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, you can put your hand down. Please speak loudly. Go ahead, Mr. Davis.
Please state your name for the record.
We see Mike Ndwaguba.
Mr. Ndwaguba, would you tell us that you are here today to enforce your divorce decree for possession of your children? Is that correct?
Yes.
How many children do you have?
3 children.
Okay. And is this in regards to all 3 children?
Yes, sir.
All right. And in the petition is named the 3 children. Would you name your 3 children?
Yes. My first daughter is Ifoma Ndwaguba. Second is Ifani Ndwaguba, and third is Chidera Ndwaguba.
Now, is it correct that
Mr. Davis, would you have your client spell those names, please?
Yes.
The first Ifoma, IFEOMA. Second, Ifani, IFEANYI Ndwaguba, and Chidera, CHIDERA Ndwaguba.
Thank you.
Your Honor, this is my first time here in Travis County. The exhibits that we uploaded, do you have those?
I do.
Okay, I'm going to refer to exhibit number 1, which is a chart for when the father was denied possession. And then I'll ask him questions about the timing.
I'm going to put that up on screen share. All right, go ahead.
Okay. Mr. Ndwaguba, I'm going to refer to you as the father to make it easier to say your name over and over, okay?
Okay.
All right. As the father, is it true that you were supposed to have visitation from July 1st to July 31st with your 3 children because you did not give a notice prior to April the 15th?
Yes, that's correct.
On July 1st, were your 3 children with you?
Yes, they were with me on July 1st.
Okay. Sometime after that, did the mother take the children from you?
Yes, she took them on July the 4th.
And had you told her that she was not supposed to take the children on July the 4th?
Yes, I did.
Now, is there a video showing her going to your house and taking the children from your house?
Yes, there is a video.
Your Honor, we would like to, how was that video made, exhibit number 10?
This was captured on my video doorbell. I have a Nest video doorbell at the front door.
Okay. And you have reviewed this video, is that correct?
Yes, I have.
And it is a true and accurate depiction of what happened on July the 4th?
Yes, yes it is.
And the picture of the lady in the window on your porch, is that the mother of the children?
Yes.
Okay, if we could play that video now.
Well, we're not going to play it until it gets admitted into evidence.
Oh, okay, I move to admit exhibit number 10.
Your Honor, I would object. There was no testimony about Mr. Nguba knowing how the video works. If the video is an accurate depiction, it's not properly authenticated. And as a side note, my client has now logged in, Your Honor. I don't know if you can see her.
I've admitted her.
Thank you.
All right. Mr. Davis, do you want to lay the predicate for this?
Mr. Nguba, are you familiar with the workings of your Nest doorbell video?
Yes, I am.
And did you copy this clip from that Nest doorbell video?
Yes.
Is it an accurate depiction of what happened that day?
Yes.
Have you made any alterations to the video?
No, I have not.
And so it's a fair and accurate description of what happened that day.
Yes.
Your Honor, we move to admit exhibit number 10.
Any objection, Ms. Kennedy?
No, Your Honor.
All right, it's admitted. You want to play it now, Mr. Davis?
Yes,
I'll play it on, can y'all see it on screen share?
I can.
All right, I'm gonna play it now. All right.
Okay,
Davis?
I'm going to speak to the father again. Had you communicated prior to June the 3rd, July the 3rd, that your ex-wife was not supposed to pick up the children?
Yes, I communicated that to her.
And you made it clear that you were supposed to have possession till the end of the month?
Yes, sir.
And is that reflected in a text message that we have as an exhibit?
Yes, it is.
Okay. That should be exhibit number 6, Your Honor.
Yes.
Speaking to the father, with regard to exhibit number 6, that is now on the screen, unfortunately, the type is very small. Do you have a copy of that text message? In that text message, did you inform the mother that you were supposed to have the children to the end of the month?
Yes, I did.
And she came and picked them up anyway.
Yes.
And as she was running out of the house, do you consider that to be involuntary taking of the kids from you?
Yes, it was.
Now, after she took the children on July the 4th, through the end of the month on July 31st, did you get to visit with the children at any time after July the 4th through July 31st?
No, I have not.
Okay. Going back to exhibit number 1, it has that you were denied possession by her taking the children from your possession.
I'm gonna object to the leading nature of all of these questions.
Overruled. Go ahead.
Speaking to the father, was it 27 days that she denied you visitation in July?
Yeah.
Okay. Then, based on the standard order where you're supposed to have the children on the 5th weekend of the month, that would have started on July 31st. Is that correct?
That is correct.
And on July 31st, your divorce decree says you're supposed to meet on Friday at Walmart. Is that correct?
That is correct.
Did you go to Walmart on Friday, July 31st?
Yes, I did.
And did you text the mother to tell her that you were there waiting for the children?
Yes, I did.
Did she show up with the children?
No, she did not.
So as a result, were you denied possession from July 31st to August 2nd for your weekend visit?
Yes, I was.
Then the next time you were supposed to have possession would be the first weekend in August, on August the 7th. Is that correct?
That is correct.
On August the 7th, did you go to the Walmart where you're supposed to exchange the children according to your decree?
Yes, I went to Walmart.
Did you, while you were there, did you text your wife, your ex-wife, to tell her that you were there and waiting for the children?
Yes, I did.
Did she show up with the children at all?
No, she did not.
So were you denied your visitation for August the 7th through August the 9th, another 2 days of visitation?
Yes, I was.
And you are claiming to the court that a total of 31 days you have been denied visitation. Is that correct?
That is correct.
Now, did you have to hire an attorney to proceed with your motion for enforcement?
Yes, I did.
And there is an invoice for legal services. And have you paid some money down on these legal services?
Yes, I have.
How much have you paid already?
$3,000.
Okay. Are you asking the court for you to be paid for your reasonable attorney's fees for this case? Did you hear me?
Not get an answer, sorry.
Yes, I am.
Okay. All right. Now, the mother of the children has filed a motion of enforcement against you. And she has claimed that on June 19th of 2020 that you took the children from her. On June the 19th, 2020, according to petitioner's exhibit number 2, would June the 19th be your weekend with the children?
Yes, it was my weekend with the kids.
And how did the children get into your possession on June the 19th?
She dropped them off at my house.
Okay. And she has complained that you had possession when she dropped them off at your house. Is that correct?
That's correct.
Okay. At the end of that weekend on June the 21st, did you communicate with the mother as to whether she was going to pick up the children on June the 21st?
Yes, I did.
Did she tell you she was going to leave the children with you for some period of time?
Yes, she did.
Did she say she was going to leave them there because she had other things to do?
Yes, she did.
Did she put that in a text message to you?
Yes, sir.
Would that be exhibit number 4? In exhibit number 4, in the third bubble, does it say that she will not be available until June the 3rd, and so the children stay with you?
Until July the 3rd. Yes, sir.
July the 3rd, I'm sorry. Yes. With regard to her complaining about you violating the order, were the children with you because she wanted the children to be with you?
Yes. Yeah, she left them with me. She wouldn't pick them up.
Okay. Text message exhibit number 4, Your Honor, I move to admit that text message.
Do you have any objection, counsel?
No, Your Honor.
All right, number 4 is admitted.
Also move to admit exhibit number 5, which he testified about texting his wife while he was at the Walmart. Move to admit exhibit number 5.
Do you have any objection, Ms. Kennedy? Ms. Kennedy, you were muted. I didn't hear you.
No
Yep.
objections, Your Honor.
All right, thank you. Number 5 is admitted.
Also, number 7 and number 6 are also text messages.
Have they been testified to?
Yes, the,
Counsel, let's not have conversations between the lawyers.
oh, yes,
Court, do you
sure.
have any objection, Ms. Kennedy?
I'm sorry, to number 7 and 8?
6 and 7.
6 and 7, no objections.
All right, number 6 is admitted. Let me look at 7.
Actually, it's number 8, Your Honor. I haven't offered number 7.
Well, that was my understanding of what you said. All right, number 8.
Number 8, no objections.
All right, 6 and 8 are admitted.
Okay. Now, just to be straight, now exhibit number 7 has to do with just presenting the legal arguments to you, Your Honor. It's like a trial brief. It is not an exhibit through a witness, number 7.
Very well.
Okay. And I move to admit exhibit number 3, the invoice for legal services.
No objections.
No objection. It's admitted.
Okay. All right, Your Honor, at this point, I will pass the witness.
All right, questions, Ms. Kennedy?
Yes, Your Honor. Thank you. May I proceed?
You may.
Sir, Isn't it true that you and your ex-wife never followed the summer possession schedule since you've been divorced?
Could you repeat?
Sure. Since your divorce, you have never exercised 30 days of summer possession in the month of July.
That's untrue. Last year, I tried to get her to agree to that, and she turned it down. She rejected, and she deprived me of visitation last year as well.
And isn't it true that typically what you do is you alternate either 1 week with you and 1 week with your ex-wife, or 2 weeks with you and 2 weeks with your ex-wife?
There were times that we did that, but not last year or yeah.
And isn't it true that you had the children from June 19th through July 4th of this year?
I did, but it was involuntary.
Objection non-responsive.
Overruled.
So when you say it was involuntary, you didn't want time with your children?
I wanted time with the children, but I also knew that she was going to deprive me of my summer hours if I didn't write on June the 21st.
And isn't it true that on June the 21st was the first time that you let your ex-wife know that you wanted to exercise 30 days in the summer?
No, it was not. That's untrue.
And sir, isn't it true that your 3 children, when they are with you, fairly frequently call and text their mother?
Yeah.
And isn't it true that you've told your children when they cry for their mother, keep crying and you won't see your mom for a long time? Haven't you told your children that?
No, never.
And haven't you called your daughter stupid?
No.
Have your children ever threatened to run away from your home?
No, they have never.
And isn't it true that your typical pattern isn't to contact your ex-wife about possession, but typically you coordinate possession with the children?
No. She actually is the one that does that, but I always try to call her to communicate our schedule, but she didn't pick up my phone calls.
You never communicate this schedule with the children?
No, we don't. No.
Pass the witness.
Anything else, Mr. Davis?
No, Your Honor.
All right. Any other witnesses, sir?
Myself,
Go ahead. I'm going to, Ms. Kennedy, unless you object, I waive the oath for an officer of the court.
I have no objection, Your Honor.
Go ahead, Mr. Davis.
Your Honor, I would like to testify that I have been a practicing attorney for 30 years in the Travis County and Williamson County area, handling family law matters. My fees for services are within the normal range of fees. I charge $300 an hour. I have produced invoice for legal services, which is exhibit number 3, which is an accurate account of my time spent on this motion for enforcement. And it also includes the service fee and the filing fee. And the total amount is $4,836.57. That's all I have, Your Honor. I move to admit exhibit number 3.
It's already been admitted to my knowledge.
Okay, all right. We're fine then.
You have any questions for him, Ms. Kennedy?
No, Your Honor, I do not.
All right. Do you have any other witnesses, Mr. Davis?
No, I do not, Your Honor.
All right. Ms. Kennedy, do you have witnesses?
Yes, I would call my client.
All right. Ma'am, would you raise your right hand, please? Do you solemnly swear or affirm that any testimony you may give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right. You're gonna have to talk louder. You're very difficult to hear. Can you turn up your volume?
Yes.
All right. You can put your hand down, ma'am. Go ahead, Ms. Kennedy.
Thank you, Your Honor. Ma'am, can you please state and spell your name for the court's record?
My name is Chinoye Jane Ndwaguba. CHINONYE. I'm Jane, Nduaguba.
All right, Shane, are you able to hear her?
I can hear her. It'd be easier if we could take down the share screen and I could see her.
I can take it down, but if you want to see any exhibits, we'll have to put it back up. All right. Go ahead, Kennedy, and be sure and speak up, ma'am.
Yes,
Thank you, Your Honor. Ma'am, you are the mother of the 3 children that we're here to talk about today, correct?
yes, I am.
And did you see the video that was played where you went to pick the children up?
Yes, I did.
And was that a fair and accurate depiction of what happened that day?
Before that happened, my kids had called me. They were planning on running away.
Objection, Your Honor.
Sustained.
Now, you said your
Counsel, just FYI, it's my policy that I don't allow either parent in a case like this to testify about anything the children might say. We just get into swearing matches and waste time. So let's not attempt to do that. That is going to be an automatic sustaining of a hearsay objection. Let's go ahead.
And so without going into what your children said, were they upset when they called you?
Yes, they were.
And when you say they were upset, were they crying?
Objection, Your Honor.
What's the objection, Mr. Davis?
She's just trying to get hearsay in, but I guess she can testify that they were crying.
I think she can overrule the objection. Let's go ahead.
And how long was your conversation with your children?
It was about 2 minutes.
And is that what prompted you to go pick them up?
Yes,
Did you fear for their safety at that time?
yes, I did.
And was this the first time that your children had behaved in this manner where you were afraid for their safety?
That was the first time they told me they wanted to run away.
Objection, Your Honor.
Sustained.
Ma'am, you can't tell me what your children said, so please listen very carefully to the questions I ask, okay?
Okay.
Now, your children had been with your ex-husband since June 19th, correct?
Yes,
Now, he says that was involuntary. Had you all agreed that he would have the children for those 2 weeks?
we always did that every summer. We have 2 weeks in June, 2 weeks in July for the past 6 years.
So he would take 2 weeks in June and then 2 weeks in July.
Yes,
And when did you find out that that's not what he wanted to do?
the Sunday before.
Okay. And how did, again, not with going into what they said, but how did the kids react whenever you told them that they would be spending a 30-day period with their father?
They were crying,
All 3 of them, or?
all 3 of them.
Now, have you ever heard it said that your ex says to your kids, keep crying and you won't see your mom for a long time?
Objection, Your Honor.
Yes, they texted him.
Ma'am, when a lawyer makes an objection, you stop talking immediately. Clear?
Yes, sir.
All right, I'll sustain the objection.
Okay, and I'm sorry, ma'am, had he texted that to you?
They texted him and they texted me.
Okay. Now, does he coordinate the possession pickups with you or with the children?
With the children.
Now, he said that you refused to answer his calls and refused to participate. Is that true?
That is not true. He sends me text and I respond.
Okay. Would you prefer that he respond to and coordinate pickups and drop-offs with you?
I prefer that he text me.
Have you asked him to text you?
I didn't ask him to text me.
Now, you're asking for a guardian ad litem for your children. Is that
Yes, I am.
correct?
Yes, I am.
And do you think that is important so that you can get back on a regular possession schedule?
Yes, please.
What is happening right now when you try to get the kids to get into the car to go visit their father?
My children refuse to go. They cannot sleep.
Objection, Your Honor.
What's your objection?
She's saying what the children said.
She's saying what the children do. Overrule the objection.
Okay.
Go ahead.
So they refuse to go. Will they get in the car?
No, I chase them around, but no.
What do you mean you chase them around?
I asked them, let's go, and they beg me, please, mommy, don't let me go there. They don't eat when I tell them they're going there. They have anxiety.
So they show anxiety. They run away from you when you try to get them in the car.
Yes, and they beg me to take them to the police instead, to police custody.
Objection, Your Honor.
Sustain.
Hey, ma'am, remember, you can't say what the kids said, okay?
Okay.
Now, have your kids ever threatened to injure themselves if they had to go to their dad?
Yes, they have.
And which child was that?
The last child.
Objection, Your Honor.
Sustained. Ms. Kennedy, I've made my position pretty clear on that.
Your Honor, I think with this particular situation that I could get it in under the excited utterance exception to the hearsay rule.
I don't agree. I've sustained the objection.
Okay. Now, ma'am, you have hired me to file a motion for enforcement against your husband, ex-husband, correct?
Yes.
And you believe he was in violation for keeping the children June 19th through July 4th, correct?
Yes.
And that was because that was not your agreement, correct?
Yes.
And so you're asking that attorney's fees be awarded for your enforcement action, correct?
Yes.
I would like to offer petitioners exhibit P2 or exhibit P2 and P3, which are a summary of the billings and then redacted billing statements.
Which ones are you offering?
P2 and P3.
Ms. Kennedy? Ms.
Yes.
Kennedy, I think we're gonna have a problem because I have you as respondent. Dad's already admitted exhibits as petitioners.
Let's call this respondents exhibit 2. We're going to refer to Ms. Kennedy's exhibits all as respondents exhibits, and we can change the designation by hand when we need to. I'm also referring to her as respondent.
So, ma'am, are you asking that you be reimbursed $3,519.20 for your enforcement action?
Yes, I am.
And what is the most important thing for you today? Is that to get a guardian ad litem for your children?
Yes, please. Yes.
And do you believe that's necessary and in their best interest?
Yes, please.
Do you know how you would get them to go on visits without the help of a guardian ad litem?
I have no idea. I don't know how.
Ask the witness.
Questions, Mr. Davis?
Yes, ma'am. How would you like me to refer to you? Your last name?
Yes, that's fine.
Okay. Ms. Doguba, is it true that you took the children over to their dad's house on June the 19th?
Yes, I did.
And the children got out of the car and went into his house. Is that correct?
Yes.
And that's the same thing prior to June the 19th. That's the same thing they would do every time they went to visit their dad. Is that correct?
Yes.
Okay. So any problems that you are referring to are after June the 19th. Is that correct?
Yes.
Now, on June the 19th, you sent a text, well, excuse me, on June the 21st, you sent a text to the father telling him that you would not be available until July the 3rd. Is that correct?
Yes.
Okay, which means you were not going to pick up the children, correct?
Yes.
And after you told him you were not going to be available to July the 3rd, you actually showed up on July the 4th and took the children anyway. Is that correct?
The children called me. They were in distress.
Did you go and pick up the children?
Yes. Yes, I did.
And did the father tell you that he intended to keep the children for the month of July in his text?
Yes, he did.
And the text was to you, is that correct?
Yes.
And
But
when
I
you
have
talked,
everything.
and when you talked about the visitation from June the 21st through July the 3rd, those text messages about the children were between you and the father, is that correct?
Yes.
And when the father wanted to communicate with you about picking up the children on July 31st, he texted you, is that correct?
Yes, he texted me.
And on August the 7th, when he was at the Walmart waiting on the children, he texted you, is that correct?
Yes.
Now, isn't it true that you have told the children that father is trying to put you in jail?
That is not correct.
Okay, how do the children know about jail if you didn't tell them?
I didn't tell them.
Objection calls for speculation.
Do you know if,
Go ahead.
I'll ask another question. Do you know if someone else in your family told the children that father was trying to put you in jail?
Objection calls for speculation.
Overall, asked if she knew.
Do you know if any other family member told the children that the father was trying to put you in jail?
I don't know if any of my family members told them.
Have you seen your children send a text message to their dad asking him why he's trying to put you in jail?
When I got home, they told me that they sent a text message to their dad.
So are you aware that they mentioned that you were going to be put in jail?
Yes, I was aware.
Objection as to
They showed
hearsay
me.
with the.
Sustained.
And did you,
Sustained. Mr. Davis?
yeah,
Objection, please allow me to rule.
yes,
Sustain the objection as to hearsay. Let's move on.
okay. During the time period from June 19th to July the 3rd, during that time period, did the children at any time contact you wanting to come home?
No, they didn't. We just texted.
Now, because of this litigation, now all of a sudden the children don't want to be with their dad. Is that what you're telling the court?
That is not true.
Okay, but this is the first time it's happened ever since this litigation. Is that correct?
That is not true.
Okay. I asked you previously if the children went to their father's house without any problem. And as a matter of fact, you always took them to the father's house. Is that
Yes.
right?
I've never denied their father from seeing them.
Okay.
This situation was different.
Now, when you're supposed to allow the father to have visitation tomorrow, and you're supposed to meet him at 6 o'clock at Walmart. Can you pick the children up and take them to Walmart and be there at 6 o'clock?
Can anybody come get the kids in the car? Because they are bigger than me. I cannot put them in the car.
Well, you don't have to tell the children where you're going, do you?
Mr. Davis, tomorrow is speculation. Let's move on.
Okay. Can you take the children do you intend to take the children to Walmart tomorrow at 6 o'clock?
I intend to take the kids if they get into the car. I intend to take the children. If they get into the car, I'm happy to take them there.
Pass the witness, Your Honor.
Anything else, Ms. Kennedy?
Just a few more questions, Your Honor. Ma'am, you said that this situation is different. Why is this situation different?
My children cannot sleep. They have anxiety. They are scared. So a lot had happened there. I don't live there, but things are not the same. And when kids act that way, it's hard for me to overlook. And that's why I'm asking for the court to appoint somebody to talk to these children.
And when did you start noticing a change in the situation?
It started over time, but they complained, but not a lot. But this last time, when they spent 2 weeks, they told me they never wanted to go there. I'm the one trying to convince them to talk to their dad and see how they can mend things with them. but I can only do so much.
And there was some conversations about during that week of June 19th through July the 3rd, you not being available. Now, why were you not available?
I had a class that I was taking, and because I thought that we always do 2 weeks, so I registered for the class with the hope that we would take them.
You were under the impression that the children were going to be there 2 weeks.
Yes, like we always did in the past 6 years.
No further questions, Your Honor.
Anything else, Mr. Davis?
Yes, I want to ask the mom few more questions. Isn't it true that as far as the schedule is concerned, you made up the schedule and told the father when he was going to see the children in the summertime? Isn't that correct?
That is not correct.
Wait, stop.
Yes.
Yes. Talking about the 2013 order?
Yes.
That's not relevant now. Who made it up? Let's go on.
No, I'm sorry, Your Honor. I might have misunderstood your question. I am pointing out that the 2013 order is a standard order that provides for him to have visitation from July 1st to July 31st. But isn't it true, Mom, you decided that the visitation would be different?
No, sir. He decides when he wants them, and I make them available all the time. He decides.
And are you saying that you've made them available every summer?
Yes, sir. Every summer.
Okay, and everything has gone fine, and they've been fine staying with the father. Is that correct?
Yes, sir. It's been 2 weeks
Okay.
in June, 2 weeks in July.
Now, this year, you took the kids over to the father's house on June the 19th. Is that correct?
Yes, sir.
And they stayed with the father until July the 4th.
Yes.
Is that correct? And that was the last time the father saw the children. Is that correct?
Yes.
And so therefore, nothing has happened between the father and the children other than you taking them on July the 4th. Is that correct?
That is not correct.
The father has not had contact with the children since
He
July
calls
the 4th.
He calls them on the phone and they exchange text messages.
He has not had any personal contact with the children since July 4th.
No, he has not.
Okay, pass the witness, Your Honor.
Anything else, Ms. Kennedy?
Yes, Your Honor, one last question. And to be clear, on each of the occasions where it's been your ex-husband's period of possession, you have attempted to make the children get in the car, correct?
Yes, I have.
And will they do that?
No, they would not.
And what do they do?
They run away. They cry, they beg. They don't even come close.
That's all I have, Your Honor.
All right. Any other witnesses, Ms. Kennedy?
Just myself on attorney's fees, Your Honor.
You may testify to them if you like. I did not hear any evidence which would justify your motion to enforce and don't intend to order attorney's fees for your client.
So then I don't need to testify, Your Honor.
All right. Do you have any other witnesses?
No, Your Honor.
All right. Do you have any rebuttal witnesses, Mr. Davis?
No, Your Honor.
Both sides rest and close.
Yes, Your Honor.
Yes, Your Honor.
All right. Following will be the order of the court. I find that there is sufficient evidence to find that the respondent, Ms. Taguba, and excuse my pronunciation, Ms. Taguba, is in contempt of court. I make no finding today, but make a deferred finding of contempt, provided that the order is not violated in the future. Don't make any orders to attorney's fees for the same purpose.
Attorney's fees would be deferred
As well.
as well.
Yes, sir. Both jail time and attorney's fees are deferred, assuming no future violations of the order. I'm going to find that guardian ad litem is necessary, and I will appoint the Travis County Domestic Relations Office with specific instructions to provide their professional opinion on a schedule for possession and access. However, the existing schedule will be in force in full until further order of the court. So the parties will be required to deliver the children as per the existing order. I'm further going to order that there'll be no future communication by the parties by any means other than Our Family Wizard. Each party is ordered to download that app and to pay the fee for an annual membership to Our Family Wizard. All future communication should be through that, with the exception of emergencies, either or a child in their possession is in a hospital or within 30 minutes of the visitation time to indicate that they're running late or whatever the emergency is. But other than that, all future communications should be through Our Family Wizard. All right.
Your Honor, I have one question.
Yes, sir.
When I draft this order, if we're going to defer a punishment, should we state the number of days that are being deferred?
I have not in the past as a practice. I don't know what the Travis County practice is, but the judge that would hear any future hearing on that would.
Okay.
This is a criminal contempt, so you don't state the days other than to say that this deferment will last for 1 year. I should have said that.
Okay. All right, Your Honor.
All right. Anything else, Mr. Davis?
That's it, Your Honor.
Ms. Kennedy?
Nothing.
All right. I'm going to ask Mr. Davis to prepare an order, submit it to Ms. Kennedy for approval only as to form, forward it to the court coordinator, Ms. Lozano, the court administrator, and she will forward it to me for signature. If there's nothing,
Thank you.
if there's nothing further, you're all excused.
Thank you.
All right. Thank you.
So she's supposed to give the kids up tomorrow
Yes.
or go to jail.
All right.
You can stop.
Turn off the YouTube.